Hello, I'm David Wilson, Solicitor Advocate and Partner at Digby Brown LLP. The Digby Brown are, of course, the 2010 winners of the Scott & Co Award for Litigation Team of the Year. Today I want to speak to you about claims under Section 1.4 of the Damages Scotland Act 1976, claims that are generally called loss of society claims. Now, the definition of compensation is to put somebody back into the place that they were had the accident have happened. Unfortunately, in such tragic circumstances as fatal claims, that's just impossible. How can you ever compensate somebody for the loss of a child or the loss of a husband, wife or a parent? However, the courts are required to do that. Now, the most significant authority in looking at valuations for fatal claims is, of course, Shahir against British Aerospace Flying College Limited, 2003 Scots Law Times 791. This is an appeal court case in which the court looked at a body of jury awards and decided that the going rate, as it were, from the precedents of judge awards were out of touch, to use their own phrase, and therefore they awarded £20,000 for a parent who'd lost an adult child. Now, Shahir has become very much the standard to judge awards by, and we see the hierarchy of awards have increased since Shahir. Widows or widowers generally get in the region of £35,000 to £40,000. We see that in the case of Weir against Robertson Group Construction Limited. And also adult children who have lost parents have got higher awards, and so on. What is interesting, of course, is that since Shahir there has been one jury award, Gillis v Lynch, in which a parent was awarded by a jury for the loss of their adult child the sum of £80,000. That's 4 times the sort of award suggested by the Court of Appeal in Shahir. Now, remember, in Shahir they talked about having to have regard of a body of jury awards. Now, Gillis v Lynch is only one award, and certainly it is perhaps a concern for defenders that if there are more jury awards, then we will get the situation again where the appeal court will look at these jury awards and say, well, perhaps we're out of touch again, and the Shahir level should be increased considerably again. From my experience as a pursuer personal injury lawyer dealing with fatal claims, I would, where appropriate, always seek a jury, because in these cases the defendants are more than likely than not willing to offer you settlements significantly higher than those that we see set out by the precedents in Shahir. If anybody has a fatal claim and wants some advice or a second opinion on it, feel free to contact me at Digby Brown. Thank you.